In late April 2017, a federal court announced a major decision that has implications for healthcare providers nationwide. The U.S. Court of Appeals for the 11th Circuit ruled that several deaf patients could recover disability discrimination money damages against their hospital because of the hospital's improper use of video remote interpreting, or VRI, to communicate with its patients. The 11th Circuit, whose decisions are legally binding in Alabama, Georgia, and Florida, provided important legal standards for when a healthcare provider's use of video remote interpreting to communicate with deaf patients can lead to a liability under two federal laws, the Rehabilitation Act of 1973 and the Americans with Disabilities Act. Federal appeals court decisions are given great deference and attention by courts across the country, beyond the area where the decisions are legally binding. This decision will affect and influence courts and healthcare providers in all states. Five patients filed complaints against hospitals and nurses for not providing a live in-person interpreter. When they were questioned, the nurses and the hospital were not in denial of these accusations. In regards to the ruling, citing the examples of these and other deaf patients, the 11th Circuit ruled that a jury could find that five deaf patients were denied effective communication, that nurses were aware of the denials, and that nurses refused to correct the denials. The evidence indicates that the nurses, knowing the patients required an interpretive aid, relied on the VRI to facilitate communication with the patients, were put on notice that the VRI was not accommodating of the patients, and chose to persist in using the VRI without correcting its deficiencies. In fact, it appears that the nurses even abandoned the VRI altogether at times without providing an alternative interpretive aid. The appeals court also criticized the hospital's VRI policies. The court essentially decided that the hospital's policies enabled the staff's disability discrimination. The hospital's VRI policy provides hospital staff no guidance on when the VRI or other accommodation is appropriate. Nurses are afforded complete discretion in implementing the policy. The record supports a finding that nurses' decisions about when to provide and when to abandon the VRI are generally not subject to reversal. Unless this lawsuit is settled by the patients and the hospital, the case will move forward and will be set for trial and other hearings to assess the amount of money damages owed for disability discrimination. This decision is one of the most significant concerning VRI and effective communications with deaf and hard of hearing people. The Americans with Disabilities Act, or ADA, cases continue to be hotly and widely litigated throughout the United States. More court actions like this one will undoubtedly unfold, resulting in additional ADA legal requirements for organizations to follow. The case described is Sunderland versus Bethesda Hospital Incorporated, U.S. Court of Appeals for the 11th Circuit, April 27, 2017. Read some of Bruce Edelson's other blog posts to learn more about developments in language access law, and be sure to contact us if you're interested in a consultation about your own organization's compliance with federal language access law. Thank you for watching.